Thank you for listening to the South Dakota Network, a service of South Dakota Public Broadcasting. Links to live events and their archives are available at sd.net. Thank you for listening to the South Dakota Network, a service of South Dakota Public Broadcasting. Links to live events and their archives are available at sd.net.
All right, I'm going to call into order the meeting of the Water Management Board for May 7th, 2026. I would like to welcome everyone participating in today's meeting or listening online. This meeting is streaming live on sd.net, a service of South Dakota Public Broadcasting. For the benefit of our online listeners, I request that all participants please identify themselves when speaking during the meeting. Participants should also remember to unmute their microphones only when speaking. The meeting is being recorded and the audio will be made available online following the meeting. To find the audio recording online, do a web search for South Dakota Boards and Commissions portal. Follow the link and select the name of the board. If members of the board's Legislative Oversight Committee are participating in the meeting remotely, please acknowledge your presence at this time. First thing on the record, Ron, we'd like to thank you for all your years of service, and this is probably your last meeting. This is your last meeting. You're done tomorrow. Ms. Greco, have the other parties reached an agreement, or?
Yes.
They have?
Mm-hmm. And they are online as well.
They are online. Mr. Shetter, are you online?
I am, Mr. Chair. Thank you. I've got authority from the Petitioners Council to represent to the board that we've agreed that the board take no action in matter 8982-3, and whether you elect to defer or otherwise table that matter, the parties have agreed that no action be taken today.
And I am also online. This is Connor Shaw, the Council for Petitioners. I can concur with Paul's statement there. Thank you.
All right, thank you. Sports preference on that, you want to table that?
Don't we usually defer them?
Well, yeah, I mean, I think you would need to do this by motion.
Yeah.
So, yeah, I mean, if you would like to defer them or not, it's up to you, but just take a motion.
So do I hear a motion to defer the hearing on permit 8982-3? our next meeting in July.
So moved. So moved. Second.
Okay. Could take a roll call on that one.
Holmes,
Aye.
Dixon,
Aye.
Freeman,
Aye.
Kepler,
Aye.
Holzbauer,
Aye.
Larson.
Aye. So, the hearing on permit 8982-3 is deferred, it will be heard in July of 2026. Next item on the agenda is to consider the addition of mandatory water use reporting qualifications to permit number 6662-3, Van Orstels, Inc., water right 2041 City of Viborg, and water right 4053A-3 and 520-3 Town of South Shore. Mr. Walt, handling that?
Good morning, yes. Water permit number 6662-3 and water right number 2041-3, as you said, held respectively by Van Orsdale Inc. and the City of Viborg authorized appropriations from the West Management of the Upper Vermilion, Missouri Aquifer. At present, there are 3 applications requesting appropriations from that aquifer that are in deferred status. They will actually be held or considered later in today's meeting. We are seeing some issues with the hydrologic budget potentially in that aquifer. There's been some concern as to the observation well status. So we are asking that these 2 have the mandatory reporting requirement added to them. They're currently the only non-irrigation permits out of that aquifer that aren't reporting to our program. It's the recommendation of the acting chief engineer that the qualification reading, the permit holder shall report to the chief engineer annually that the amount of water withdrawn from the Upper Vermilion, Missouri West Aquifer be added to both of those. They would be reissued with that verbiage and then required to report to us each year how much water they're using.
Any questions from the board?
I do, Mr. Chairman. You said these are the only 2 that don't report, or non-irrigation, excuse me.
Correct.
Okay. Thank you.
Comments from the state?
Just maybe there was a slight bit of language issue. There are only 2 non-irrigation that don't yet report.
Yeah.
Okay.
Yep.
Just in case I misheard.
All right, do I hear a motion from the board to adopt the chief engineer's recommendations?
Thomas, so moved.
Do I have a second?
Second.
Motion is, we have a second, all in favor say aye. Aye.
Aye.
All opposed say nay. Hearing none, the recommendations are adopted. Next item on the agenda is to reconsider deferred water permit application number 8763-3, B&K Dairy Farms LLC.
I'm gonna jump in really fast and say that there are 2 other water rights that we had listed at the beginning of this consideration that you had read off, both held by the town of South Shore, and I'm going to request that the board take no action on those today due to an error in the notice that was sent to the town of South Shore.
So do you do anything different?
Nope.
Okay, thank you. Mr. Mathewitz, are you handling this one?
Good morning, Mr. Chairman, members of the board. I am Adam Mathewitz, Acting Chief Engineer of the Water Rights Program. Just because of our level of preparedness that we needed for this board hearing, our counsel, Emily Greco, is gonna kind of do a little bit more question and answer form, just so I didn't have to remember everything. But these are 3 permit applications that were originally deferred 8763-3 for B&K Dairy Farms LLC, 8797-3 for Donald D. Benson, and 8817-3 for Merlin Van Orsdel. These are all from the West Management Unit of the Upper Vermilion, Missouri Aquifer. Originally, these were deferred at the March and May meetings in 2024 of the Water Management Board for up to 2 years. And so that 2-year cycle has come to its end. And so therefore, bringing them back for reconsideration. Oh.
He had said that his petition was later, but he is on.
Actually, I have a
Ms. Greco?
What was that?
You have questions, Ms. Greco?
Yes, for Adam.
Yes.
Yes, sorry. Adam, what was your involvement in these 3 permits?
So back when they were first deferred, I was the technical report writer on the technical aspects of the availability of unappropriated water and the potential for unlawful impairment. So that was back in 2023 and 2024. And then recently, I also started the report before I became acting chief engineer and finished the report during my time as acting chief engineer, as well as created the recommendation for these 3 applications.
And so you said you both wrote the report and then the recommendation. Did other water rights staff review your report before you issued the recommendation?
Yes, water rights staff, from a technical aspect as well as administrative aspect, peer reviewed both my report and my recommendation, and we discussed the details of the recommendation, since it would be improper for me not to have that, since I also worked on the technical report. It was due to a change of position that the signature time lines up that way.
All right, and I think you kind of already explained the status history of these 3 permits. Is there anything else to add?
The recommendation I made for it, for these 3 was a continued deferral for 5 years. The only one of these was contested. It is 8817-3 for Merlin Van Orsdel. That was also originally contested when the original deferral recommendation and thus deferral approval from the board was issued.
And what is the priority date for these 3?
I do not have the priority dates in front of me, but the priority order, the oldest, the most senior is 8763-3, then it is 8797-3, with the newest priority being 8817-3.
And you said application number 8817-3 is the only contested currently.
Correct.
Why were these applications recommended for deferral originally in 2024?
Originally, when looking at the observation well data we had, there was a steep decline in the 2 observation wells completed into the aquifer at that time, of numerous feet, and there was no apparent stabilization of those water levels. Furthermore, there were several applications that had yet to be developed at all, whether putting systems in place or putting water to beneficial use with in-place systems.
What information did you review this second time around in 2026?
Besides further reviewing the hydrogeology, because there is an ongoing South Dakota Geological Survey study that we had asked them to perform following that first deferral, with recognition that we'd had further history with this aquifer and the management units back in 2012 and 2014, and this portion of the aquifer wasn't as detailed in study as the rest of it was. I also looked at withdrawals, the additional withdrawals that occurred since that initial deferral, observation well data, and then again a review of the potential for unlawful impairment in case the board were to choose to approve instead of accept the deferral recommendation.
And what did the information show regarding the withdrawals?
There was, on average, a slight decrease of withdrawals over the last, using 10-year averages, which is which is something we regularly do to better account for changes in irrigation systems primarily. but also in terms of making sure we account for changes in how much just permits there are within an aquifer. I believe the average over that time period was 15 or 20 acre feet decrease in irrigation. However, again, it's only over those 2 years. We had one drier year, one slightly wetter year, if I remember correctly, between those two.
Have all the permits authorized to withdraw from this aquifer been developed?
No, there is one that was a transfer of acres and diversion rate that was approved earlier this year. They had not developed at their previous site at all. And so if they hadn't developed then, they have not had the opportunity to irrigate yet this year. So at least that one, and then there was, during another review of data, they had reported no irrigation. However, I do believe the system is in place, so they just had not used it yet.
What is the estimated average annual recharge?
So from the mathematics of using it and using an updated area, again, it's a in-progress area from the South Dakota Geological Survey. They are still further reviewing and refining as they've come to finishing their report. The estimated average annual recharge using the range from Hedges and others for buried confined aquifers, so this is an estimated range, there is not one specific to this aquifer, it comes to 172 to 344 acre feet per year.
And did you also calculate an approximate aquifer outflow?
Yes, because when you look at the withdrawal numbers that have historically been above the 344 without historic decline in the observation wells, that indicates that average using that broad range is simply low. So then my predecessor back in 2012 and 2014, when we first looked at this aquifer, did a outflow. I have since updated that using better data and more data as we have surveyed our well casing tops for as much accuracy as possible, as well as I refined his methodology to account for some less than ideal formatting and how he did his calculations. The estimated outflow from the aquifer using our updated survey ranges from 1,216 acre feet per year to 1,984, depending on which observation well set you use, and whether you look at our period of record, which would be 1978 for those wells that we have available, or if you consider the last 10 years of available data, because we were not able to get readings in 2019 and 2020 between flooding in Turner County area, as well as the COVID issues with having our seasonal staff go out at that point with the restrictions that we had. So that range across that time period.
What did the observation well data show?
In general, the observation well data showed that there has been some stabilization of the water level since 2023, which was the end of the sharp decline. Unfortunately, we have one brand new observation well that we brought online last year. It does mirror the other two in broad terms, and again, starting to show some stabilization. However, with only 3 years of data and considering the smaller size of this aquifer being relatively small, with the total withdrawals on average being in 1,650 acre feet per year range, means that the aquifer can be more reactive to any increase in pumping, and therefore that shorter camera stabilization is not necessarily fully indicative that whether it's over appropriated or not.
So based on all this information, what was your conclusion regarding the availability of unappropriated water?
My conclusion was, at this time, with the information available, I could not say that there was a reasonable probability there was unappropriated water available, and therefore would recommend continued deferral of these 3 applications.
How long did you recommend the deferral for?
5 years.
And why did you recommend 5 years?
5 years, that was to align with the practice that we were had done an establishment of statute for the fully appropriated Tulare aquifers, and also to give the brand-new well as much time to hopefully go through at least a portion of a wet and dry cycle. And that's especially valuable because we have installed pressure transducers and data loggers in all three of the observation wells that we are absolutely certain are in the aquifer. There are a couple others. Again, that's going to be waiting for the South Dakota Geologic Survey because there's much deeper science involved with that is outside of our capabilities to determine for a couple of those. So we're focusing on the three, and they are the ones that are shown in my report.
And then you also reviewed the potential for unlawful impairment.
Yes, I did.
Can you describe that review?
I looked at the distance between the proposed well locations and the nearby appropriative wells within the aquifer, as well as domestic wells on file. The nearest to either an appropriative well or a domestic well is application 8817-3, which has the nearest appropriative well is a half mile away, although that is, so that one is for Merlin Van Orsdal, but the nearest appropriative well is for Van Orsdal's Inc. And then the nearest domestic well on file was approximately 0.3 miles away, again from 8817-3. For both of the other applications, the appropriative and domestic wells were even further away from the proposed well location. When considering the confined condition of the UVM West Aquifer, the Upper Vermilion, Missouri West, even with those distances relatively close, the aquifer is highly transmissive. We have other areas where there's even more concentration of appropriative wells that are not necessarily causing well interference. Furthermore, we had one complaint in the past. However, in dealing with that potential complaint, it was determined that the well at that time, they had their pump setting at 60 feet. However, their top of their aquifer, based on our own nearby observation well and everything else, we expected to be quite a bit deeper. And that also includes the State Geologic Service lithologic log. Furthermore, the issue with the well that had issue was that it's near the edge of aquifer.
Near the what?
Edge of the aquifer. So when you do drawdown near the edge of an aquifer, you have what's called reflected drawdown. Essentially, that boundary condition increases your drawdown in your own well. And it ended up being essentially a pump placement issue. However, there was the notable decline in those two observation wells, which an overall lowering of the water level in an aquifer, particularly if it gets to desaturating and dewatering the saturated portions, which at this time it isn't, but it's not that far away. That could be considered an unlawful impairment. We have been fortunate that that has not been a case we have had to deal with.
What conclusion did you draw from your review of the potential for unlawful impairment?
That there is a reasonable probability there would be no unlawful impairment from the pumping of any one individual permit on another permit or another adequate domestic well. However, that concern over the overall lowering, as seen in both observation wells that are far enough apart that they would be representative of most of the aquifer, did lead to concern that I was not certain that there would be a potential for unlawful impairment based on that overall potential lowering.
Is there currently an ongoing study of this aquifer?
Yes, as stated a couple of times, the South Dakota Geological Survey is in the process of wrapping up their study. I believe at this point they're doing some final geology work and mapping and writing of their report.
So to conclude, the final recommendation is deferral for up to 5 years?
Yes, the final recommendation was deferral up to 5 years to continue monitoring the water levels in those three observation wells, allow the one permit that I'm absolutely certain has not been developed since we just issued the transfer of acreage, and to allow the one that had, as according to the reporting, not pumped water, allow them time to potentially place some water to actual use.
Those are all the questions I have. I believe the petitioner is online.
Say again, Ms. Griffin,
I said those are all the questions I have, but I think the petitioner is online.
is online, okay.
That'd be Scott Van Orstel, label as Scott.
Sir, do
Yes, I'm here.
you have any questions for Mr. Mathewitz?
No, I do not.
Questions from the board? Yes,
I have one question. You said that the 8817 at Norrisdale was intervened last time. It was intervened where the applicant actually intervened, resisting the deferral, is that correct?
Correct.
Okay, thank you.
Mr. Epler?
Scott's line, but Scott turned in a comment that talked about a different technique he's gonna use for irrigation. And can you directly speak to that, Adam, please?
Mr. Van Orsdel's commentary, and that also was brought up at the first one, is he is using what is, I believe it's a 360 rain system, which is an autonomous system that is more efficient than a standard center pivot, based on all of their documentation and their field studies that they've provided across their regions that they've done. When I reviewed Mr. Van Orsdel's data, I did just look at the total. I will say I don't have his month-by-month breakdown. It was less than his per acre inches was less than his neighbors. But I don't remember if there were 1 or 2 years of data off the top of my head. That system, following my knowledge of irrigation, because it essentially applies the water at the land surface through drag tubes. There are other methodologies, but that seems to be the primary one they recommend. It does apply closer to the ground surface, therefore you have less loss to evaporation, as well as less loss of just spilling it on the leaves, particularly with corn, versus a center pivot. Even if you have the drop tubes on the center pivot, sometimes your drop tubes and therefore your nozzles or sprinklers are still several feet off the ground.
So that didn't change any of your suggestions?
No, my analysis is based on the total aquifer and total water use, and primarily because there are no future use permits in this aquifer. Our observation wells are a direct reflection of the water being used. Now, if there were future use permits, obviously I would have to do a better accounting for them, because that's potential water to be used. But here in this case,
That's potential water use.
what potential water to be used, but in this case, because there aren't any, the observation wells do directly track what is occurring in the aquifer from pumping.
Thank you, Mr.
Any additional questions from the board? So, Mr. Mathewitz, if I understand you wanted to defer, your recommendation is to defer all 3 of these permits, is that correct?
Correct.
For each for a period of 5 years?
5 years, yes.
Do I have a motion to either, to adopt the?
Bill? Do you need to let the petitioner?
He didn't have a question, but he may want to talk.
I asked him any questions.
No, he might not have questions for Adam, but he might still wish to give testimony on his own behalf.
Sir, do you have any questions or a witness you want to call?
Are you asking me?
Yes.
It's just hard for me. I hold that permit you guys are asking me to report also the gallons being used. And I'm being told to use more water on less acres. All I'm asking for is to use the water the way it's supposed to be on more acres. I have a significant investment. The other well that was just issued, they changed acreage or location, they're using less acreage. I have a hard time with this, asking to use less water, but being told to use more on less acres. And to have to wait 2 years is enough, but to go another 5 years is just, it's beyond me how to get that through. I don't know what else to say or how to petition something that makes sense like that. I don't know. I guess if you have any questions for me, go ahead and ask, but I don't know how else to approach this. I did talk to my district representative, but that was Mr. Richard Basgard, and he unfortunately passed away last fall in a farm accident. And I have spoken to the fellow that took his position, and he fully understands what I'm trying to do, but I should not have to go through him, but he is willing to work with me. I just don't know what else to say or how to approach this, I guess.
Questions from the board? Sir, you don't have any witnesses that are gonna testify on your behalf, though, correct?
What's that?
You don't have any witnesses that are gonna testify on your behalf, correct?
No, just me, myself.
I have a question.
Thank you, Mr. Columbus.
Yeah, Mr. Van Norsdale, did you have access to, Mr. Matowitz' report to review?
Yes, I did.
So, and then you heard his testimony about, and from the question and answer from the attorney, correct?
Yes, I did.
Okay, and so I think Mr. Matowitz, as a board, we look at these and we have to look at the overall aquifer, from my perspective, and while it is difficult for each individual instance, we're tasked with looking at the aquifer as a whole, as has been presented by Mr. Matowitz. So I, for one, appreciate your concern, but I just wanted to make a few comments regarding how we're tasked to look at these. That's all I had.
And would the board allow Mr. Mathewitz to make a response to his commentary?
Sure.
Adam Mathewitz, Acting Chief Engineer of the Water Rights Program. One of the things Scott has said is that he is wanting to put on less water than he is being asked to put on. I think a more accurate way of stating that than his current permit allows. Again, permits are based on a diversion rate, which is the maximum pump rate, and the number of acres. And for irrigation, unless noted in some of our older permits, irrigation is allowed up to 2 feet of water per year. However, we have done multiple individual studies, and including one I did for this aquifer, that we know most irrigators do not apply that much water, with the exception of golf courses and some other turf operations, and some of those are allowed up to 3 feet of water per year. However, when we look at that hydrologic budget, we do consider the average of what they actually pump, because they report, and so we use the reported number.
Thank you, Mr. Matowitz. Sir, do you have any comments to that statement?
No, I do not. I guess, yeah, I don't know how else to explain this, but it's hard for me. I understand he did a good job of explaining the rain system. I appreciate that. I guess I'll never use the amount of water that you have allowed me, however you want to say it. I'll never use that. I'll use a third of what you allowed me. Even on the total extra 91 acres, if I would be granted that, I would use less than that. So I don't know how else to get that reworded or amended in my permit, if that's even possible. And as far as the 5 years, I just think that's a little absurd. 2 is plenty enough, if there's any consideration there. But I don't know, is there any way the permit could be amended for my usage that I'm granted right now? I guess I don't even know if I want to give that up. If the water you guys feel is that tight, I don't know if I want to give that up.
You don't know if you want to give up your current permit, is that what you're saying?
Well, I don't know if my permit could be amended to a less usage rate, but I don't know if I want to give that up if things are so tight, is what I'm saying.
And that's
then I'll just,
that's your choice, sir. You could always file an application with the engineer, with the board, and it'll be evaluated.
well, I guess that's kind of what I've been trying to do the last 2 times I've met with you, but I don't know how else to say it or to amend it, I guess.
The chief engineer has found that there was not sufficient water to grant what your request is, though.
But I'm not asking to pump more, I'm asking to pump less on more acres.
So,
Go ahead.
Mr. Chairman, Scott's asking a viable question, and so I'm looking at staff. I understand your answer, Mr. Chairman, you could always apply for a permit. But staff, have you worked with Scott? I'm assuming you have, like you have other permittees, and try to resolve what he's working toward. Always under, at least my own personal drive is to help these individual farmers as much as we can. Because we all know they're the lifeblood of who we are in South Dakota, and so he's asking some lots of questions. I understand the overall budget. I'm not disagreeing where we are with this, Chief Engineer. But is there anything at all, based on what you're hearing now, that would help him?
I guess I would just point to SDCL 46-1-14, which allows the board to issue any permit or license subject to terms, conditions, restrictions, qualifications, quantifications, or limitations. And so I think the board might be able to issue a permit that is less than what it's asking for under that authority.
Mr. Mathewitz, what's your comments on that? On Mr. Helfrich's question?
Adam Mathewitz, Acting Chief Engineer of the Water Rights Program. My commentary is, while under the current permit and say Mr. Van Orsdel puts up a center pivot, his rain 360 system, or 360 rain, I get the name backwards, will use less water on the same acreage. However, if he adds 2 acres, he is using more water than he is using today, potentially, because he added 2 acres. And when I look at the observation wells, which are reflective of the actual pumpage, so it doesn't matter whether he's running a 360 rain or a center pivot or watering a dairy, I am uncertain of available water. So while potentially to use less than if he used a less efficient, more traditional system, and that's what the permit would allow, I still have issues with any additional pumping. Whether that would be from one of the preceding applicants, one of which is a dairy and another of which is an irrigator that have senior priority with these deferred applications, or whether that would be from Mr. Van Orsdel.
Okay.
What about changing the deferral period to like 2 years instead of 5?
When I had discussions with our staff at that point, we picked 5 years because with this small an aquifer, I at that time, when I did my first analysis back in 2024, and then when I've redone it, believe that this aquifer is either very quickly approaching or at full appropriation, and therefore with the fully appropriated Tulare aquifers, the standard is a 5-year review in statute. That is how we came to 5 years. I initially waffled between a continued 2, because that would give approximately 5 years of data, 2023 to 2027, of which, and then we'd have, that would be a total of at least 3 years of data logger data, so the very subtleties within that, that might be, because when we manually read every couple of weeks, we might hit a low spot. And with an aquifer that's relatively small and the budget's tight, having that extra data was valuable. Because I did see something I wasn't expecting compared to the manual readings that were taken. And I realized that we happened to hit right when the one observation well close to an existing dairy was pumping, the hardest. We picked it up the same day. And then I could account for that with that data logger data in that case. So I would be amenable to 2 years, but again, I chose 5 in my recommendation based off of the statute for fully appropriated aquifers, because I do believe that is where this is going. Particularly if the next in priority date, which would be B&K Dairy, I believe their request, I'd have to look at my report here quickly, was 480 acre feet per year, which would be essentially about 50% of what's already being pumped, or 40% of what is already appropriated. Correct, yes. B&K Dairy 8763-3 is requesting up to 480 acre feet per year.
So if we went to 2 years, then you would have 5 years of data to look at in 2 years? Is that what you're saying? Because you said you had data from 23 to 27, right?
So we had additional data, which would be the 2024 data and the 2025 data for the irrigation use.
And then you had 26 to 27 if we went to.
Yes, we would have 2026 and 2027 for the deferral. And I would anticipate bringing these back, if it was 2 years, bringing these back before the board in March or May. Part of it was depending on just our workload. I had tried for March and we just had too much and it slipped to May on me. I did fail on that. That is my responsibility both as the engineer in this, but that would be the anticipation.
I would motion to amend the recommendation to a 2-year deferral.
So moved. Kepler.
Do I have a second?
Thomas, second.
So I have a second on a motion to defer reconsideration on permits 8763-3, 8797-3, and 8817-3 for 2 years. May I get a roll call on that?
Thomas,
Aye.
Dixon, Freeman,
Aye.
Kepler,
Aye.
Olsbauer,
Aye.
Larson.
Aye. So noted. Thank you, sir, for appearing today. The next motion on the agenda is to consider Held Tulare, Western Spink Hitchcock applications. Kim Grennan.
I need to swear the oath. I need to swear in.
Okay. Do you solemnly swear the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Good morning, Jen. And before you start, can you tell the board what this document is?
That is a table I prepared this week summarizing very briefly the 27 water permit applications that have been on hold in the Tulare Western Spink Hitchcock Aquifer since 2015.
And you said you created it,
Yes,
and to your knowledge, you created it.
yes.
I'd move to admit Exhibit 1.
Objections, Exhibit 1 is admitted.
All right, Ken, to kind of speed things up, instead of going through all of these individually, can you summarize for the board your findings relating to all of these held permits?
Okay, so in December 2025, the board determined that there was unappropriated water available. And so since then, I'm following statute and law for processing a water permit application. The final technical aspect of review would be the possibility of unlawful impairment on existing water rights. The Tulare Western Spink Hitchcock Aquifer is a glacial aquifer in Spink, Beetle, and potentially Han County, between Huron and Redfield. The average annual estimated recharge based on study in 1984 is 18,000 acre feet per year. The average annual withdrawal based on my analysis in 2025 is approximately 12,000 acre feet per year. Assuming the 27 applications that are considered before the board right now irrigate similar to other water permits in the aquifer, they would withdraw approximately 2,300 acre feet per year. Looking at each one in my reports, it appears that there's a likelihood that they can all develop without unlawful impairment of existing water rights. There are numerous wells completed into the aquifer in very short distance, but we have no complaints on file in Spink and Beetle County regarding unlawful impairment.
I don't have any further questions.
Any questions from the board? Hearing none, do I have a motion to adopt the engineer's recommendations?
Kepler, so moved.
Do I have a second?
Gomez, second.
All in favor, say aye.
Aye.
All opposed, say nay. Hearing none, recommendation is adopted.
Morning, Mr. Chairman, members of the board.
Oh, sure.
This is for the amended item that would added the discussion of appropriative status. Part of it was pending, Kim's there. With the approval of those 27 permit applications, since the time the board hearing in December, when it was decided that there was unappropriated water available for the Tulare Western Spink Hitchcock, we obviously processed those 27, which were held and subsequently approved in the last few minutes. We also received 25 brand new applications for the aquifer. There was discussion at the December board meeting of discomfort with approving permits that would use up the 6,000 acre feet of recharge that was in excess of withdrawals at that time. The 27 that were just approved, plus those 25, using Kim's math on estimated average annual withdrawals, brings us a little bit past 2/3 of that amount, which is 4,000 acre feet. And that was the discussed number that was mentioned. So for our processing, we would, I should mention, one of the held ones is likely to be canceled. The irrigator has called us and said they are unlikely to be able to develop at site due to electrical issues. They have subsequently applied for a new site. However, the statute does require you have to develop at that site that you were in the held one. So per that statute, he would have to apply for a new one and not be allowed to transfer that. However, in discussion with him, we agreed to make sure this got approved first potentially so that he at least would have some chance versus if the brand new one were to be denied for whatever reason. That's why that occurred. As I said though, the numbers discussed were approximately 2/3 of that 6,000 acre feet, which is 4,000. With these 25 new held, using that average, we would be slightly above that 4,000 acre feet. Assuming the technical reports, which Kim is writing, find no unlawful impairment issues that would suggest that an application should be denied or deferred for any reason, I at this time would intend to recommend approval of those 25 new ones and suggest deferral for the board's consideration since that 2/3 number was discussed. However, I would prefer if we had some more specific direction from the board on how we should proceed with that, mostly so we don't bring unnecessary applications in front of the board that you have, have a feeling that you don't need to hear at that point, or we want to make sure we proceed within your wishes because we are sort of staffed for you.
Any questions from the board? Mr. Mathewitz, so we have 25 new permits in the same area?
Yes, 25 new applications following the 27 held that were just approved.
And we just granted 27
Yes, sir.
in the same aquifer,
Yes, sir.
after sitting there for 11 years doing nothing.
Correct.
Where did the water come from?
So part of that was Kim did a better analysis on average and realized that she took a very deeper dive than we had previously and did a better job accounting for the seasonal variations within it. Some of it was, Kim looked at the applications individually. And if you need some more specific details of exactly how she did it, Kim would be much better to answer than I am in terms of the details. But essentially it was, we used a much more labor-intensive methodology because we had gone to the second 5-year review. And the observation well data still showed stable water levels that had continued. I believe some of them were even rising in the unconfined portion, which means that our original estimates were, essentially incorrect. And we adjusted as we need to.
But you're not asking this board to grant these 25 permits today, correct?
Correct. As I said, I have not made a recommendation. I am explaining where my intent is based off of what was discussed in December. And we just would like some direction to, essentially I would like to know, is that 2/3 number a relatively hard stop? Where we would go into just deferral and bring them to the board to know, or if that is a much more soft stop and we can use our engineering judgment. Trying to just get a more direct understanding from the board that what their wishes are.
It would appear to me that we're charged as a board with utilizing the waters in the state. And if there's water available, then I don't know why we keep it. Why would we put it to beneficial use? As long as recharge is covered and you guys are comfortable with it, then that's what we're supposed to do. We're supposed to put the water to beneficial use.
Okay. As I stated, there was some discussion in the December board meeting. That was something that we had noted, and if we hadn't arrived to it quite so quickly, maybe wouldn't have brought it for the board to give us more specific direction, but I understand.
But that's just my opinion.
Well, Mr. Freeman's correct. I mean, we are to use it for beneficial use, we don't store it. So, but are you gonna do a further evaluation to ensure that there's sufficient water for these additional 25 permits? There's 52 permits in one area.
Yes.
And I've been through that area, it's not very big.
No, it is not, and I have too, and there's a pivot on every corner, because I drive through that to go home to my family.
It's like where I'm from is in Mecklen Gable area, there's a pivot everywhere, but different aquifer.
Yep. So yes, that is part of Kim's analysis. She put in a great deal of detailed effort, which was peer reviewed by multiple staff. We questioned some methods. She gave a good explanation when we did our internal reviews. She presented it to the board in December, and we still concur with her methodology of approximately that 6,000 acre feet of recharge in excess of withdrawals. Again, that was that average, and using the much more detailed and just a slightly different methodology that probably is more representative than what we had done before, because she thought through it more of a statistician way than myself and Mr. Bueller when we started this in 2012, when we first kind of got into this more recent cycle of deferrals, which eventually led to the statutes that have made the held list for fully appropriated aquifers, and then this 2 subsequent 5-year reviews. We did partially as we have time then. We aren't limited by that 60 days. I can't speak for exactly how long Kim worked on this, but I believe it was well over a year of just doing math and making sure. Because at some point and on the scale of the aquifer, because there are several hundred permits, that is time consuming, and to make sure that it is correct. And that's why, that's how we found the water, as you said, Mr. Larson. But again, as I said, it was mentioned in discussion in December. I want to confirm, if the board wants us to bring it back when we're at that number, we will gladly long form notice that, so it's automatically for hearing. As I said, based on that discussion, my intent was to defer that to bring it to the board, but I will follow statute and put it to use up to that recharge number just as easily.
And we're gonna have that data when? When did you say she would have more data for us, by the summer, or?
Oh, no, I was discussing what she had done previously for how we got to the numbers that you were discussed in December. Our intent would be, if we recommended deferral, for any of those, we would essentially go back into that 5-year cycle, unless there was, a petition against that deferral recommendation, because that automatically brings it to the board, or if you as the board disagreed with that, and then we would obviously have a hearing and we would explain ourselves, and you could question and make whatever decision that you feel is appropriate.
Mr. Chairman,
Yes.
in December, we didn't quite have this much analysis, is that correct? Am I recalling correctly?
No, you had the same analysis, just not all of the, we already knew of the 27 held because they'd been held.
Right.
Did not know of the 25 new, because they occurred immediately following that December meeting. I believe there was someone calling as Ron went up to his office, or Amanda did. And there were people here the next day, because, you know, it had been held. And I understand their needs, so.
And the discussion was a little bit of apprehension by the board. I'm trying to recapture and recall the discussion in December, apprehension of the board of moving all the way up to that.
Yes.
This, and we talked about this coming back to us, which it is here today. And now we have the information that it is available and to issue these 27. But not only that, you're signaling to us that likely even more can be issued. Is that a fair summary of some of the previous discussion?
We signaled that in December, that there could be more.
Yeah.
Essentially, we said, short term, there was 6,000 acre feet of water available. These 27 held, I think Kim said 2,300 acre feet is what they would estimate it to use. And then we have another 25 new applications that came in. So 4,000 minus 23 is about 1,700 acre feet. So more requests now, and that would still leave, again, following Kim's methodology, 2,000 acre feet approximately. Now, following the approach that, as part of the reason why I recommended the deferral for the previous item was caution. These aquifers are of quite a bit different scale. You know, where the use here, I mean, we just added 2,300 acre feet of use. There, that's double of the previous aquifer. So obviously, you know, caution on scale. I myself prefer to be cautious. That's just my personality with anything that affects someone other than myself. You know, with myself, I'll do whatever, but for others, I tend to be cautious. But again, as I said, we are staff for you as the board. And I just would like some more specific direction. If we are to follow statute purely as written, we'll go till we're up towards that 6,000 acre feet. Obviously, we'll keep updating as we get applications, and if, you know, Kim or whoever does the work finds that, well, maybe it's 5,500, okay. We'll obviously go up to that number and bring it back to the board, or as the discussion, and I know, I don't remember who said it, but I believe that number is kind of obviously just that 2/3 is picked out of the air. But again, that was the discussion. And so we arrived at it a lot quicker than I was expecting. I was expecting some applications, not necessarily 25, several the day of the hearing.
Well, I would agree to follow the statute, and we will, there's nothing in law, I guess one might say that the 2/3 is in law. I mean, we're to put all the water to beneficial use, and so we'll rely upon what you present to us. I would support that as well. In other words, I would not say we need to limit it to 2/3 like we had talked previously.
I could ask you a question. Am I correct in understanding that we kind of give you the okay today? The division will go ahead and approve these permits and we won't bring them in front of us until we get close to that magic number?
So these 25 new ones would bring us to the magic 2/3 number, approximately. I believe they're just a little bit over, maybe 50 acre feet, 100 acre feet, something like that. But obviously with the potential cancellation, that gets down to like 10 acre feet. That would be, right now today, if you gave me no other direction, then my intent would be the next application, so application number 26. We would either long form notice for approval, and therefore it automatically comes to the board with a approval recommendation, or defer it in front of the board. I haven't worked out the full details of my thought. My initial thought was deferral, to give you a chance to decide on that then. But I realize with the statute saying what it is, it's just simpler for me to ask direction now. If there is, if you want to hear it when we get to that number, just hear it no matter what. And then we would make notice of, and make sure it comes to the board with a recommendation, either for deferral or approval, assuming there's no unlawful impairment consideration, obviously, because that is, we have to look at each individual application. I can't guess ahead of time where with unlawful or available unappropriated water, we have a large enough range that I can project a little bit.
Have you had any objections or opposition to any of these permits or?
Certainly none of the held applications, although one of the applicants was here yesterday, the Hofers. They were here in case there were questions. I mean, they weren't expecting any, we had no petitions. I do not know if any of the new applications have been public noticed and are through their public notice period yet, off the top of my head. I believe
Three that are through, with one report.
so. Kim pointed out that one of the first applicants did put in 3 applications. It is public noticed and it seemingly is through its period without objection. And we typically don't, with the Tulare West and Spink Hitchcock, the objections are usually in the history to the chief engineer's recommendation, which was denial in the past frequently until that held statute for that, developed that holding list came in place. And it was the applicants intervening on themselves for the chief engineer's denial recommendation. And therefore they, wanted approval and it was to come in front of the board. So that's most of the history with the Tulare Western Spink Hitchcock and recommendations versus board actions versus who intervened and how it happened.
We can have discussion on the record too. If you guys want to discuss on the record about what your thoughts are, that might be good.
I was just wondering about hearing them again after.
Do you want this on the record or do you not?
No.
Okay.
What were we saying?
Well, so if we,
Off the record?
We're not on the record, she told me off.
if we,
So, someone wanna tell me? I can't recapture it,
Okay,
I can
off
start.
the record.
We're off the record.
It's more board discussion than anything.
yeah, it's just, so if we approve. Do we need to review it again later? That's the thing.
I think my thought is that department follows their normal operating procedure, and if nobody objects, then.
If nobody,
If it comes to the board, it comes to the board, and it does. Operating under the theory that the board's job is to allocate the water, or make use of the waters. I mean, I'm not sure why it would make sense if we're not gonna just follow our normal set procedure. If they're telling us right now that there's this X amount of water available, that's kind of, I guess, trusting the program.
To me, that makes sense. I mean, we've been assured by the experts that we've got the water there, and these 25 permits, anything over that, you're gonna bring to us, or at least report to us your thoughts, once we hit that 2/3 number.
Well, I think that after the approval of these 25, if they're approved, that would reach a 2/3 number.
Right, and so then anything else
So it's gonna happen.
It's gonna come before us. Is that what you're thinking?
We would be long for noticing everything after this, the 25.
I'm trying to figure out if we're on the record and I should speak or not.
We're not.
Yeah, my initial intent was to either long form notice it for approval because the math shows water is available, or defer, which automatically is a long form and brings it to the board. I hadn't consulted directly with council or administrative staff to get exact which way we felt was best. But the intent was, once we hit that 2/3 number, which we will, assuming approval of the 25 brand new ones, that would be, you know, my intent had been to bring it back to the board because of the discussion. But if the board didn't want to see it, that was the point of having this discussion now, was if you didn't want to see it until we got to the 6,000, the 100%, then I wasn't intending to bring them in front of you until that time. Essentially, I guess the short of this is, when did you want to see them next? I guess that's probably how I should have said that.
I'd rather see them at 2/3 rather than 100%.
Yeah.
And then we'll have some additional data to go to look at the remaining.
So if we're gonna get down to the point where we're talking about motions, we should go back on.
Yeah, that's what I'm thinking.
So we're still, the 2/3 is still in
But we're
play.
not cutting off at 2/3. I just wanna make sure we're going, because we're saying the water is there, we're going to continue recommending approval, but we will long form notice them so that they will all come in front of you for you to review for continued approval, so you know how close we're getting to the cutoff.
I guess, yeah,
I think
so
that's what I'm on.
based on discussion, I would then change my previous statements about, you know, whether deferral or approval to. We would do approval pending the law and just long form notice those, any after. So essentially, whenever number 26 comes in, it'd be a long form notice, so it automatically comes to hearing.
A long form notice to approve.
Yes,
Correct.
with the recommendation to
Because
approve.
there's no basis to not approve. If they're not saying water's available,
Yeah, they can,
but we just need to see them.
Correct.
well, and we make the ultimate decision
Correct.
as to whether or not.
I'm saying their recommendation.
With the water being
Yep, so then, okay.
So why don't we go back on the record and we can kind of conclude that into a succinct, more like a succinct motion that we can make.
Is there such a thing?
I'm depending on you, but I can see what Let's go back on the record real quick. All right, do I hear a motion from the board regarding recommendations from the department on these issues of the additional permits, the appropriate status of two-layer?
Well, I will try this. I would move that the department be advised, and we recommend that they follow their normal approval for granting permits or denying permits in their judgment, that are uncontested, in that aquifer up to 2/3 of the available water. And by that, I mean they don't have to come in front of the board. Once we hit approximately 2/3 of the available water, at that time, any additional permits would be handled by the department, that you would make a recommendation to the board, but it would be brought to the board in order to make the final determination.
Thank you, Mr. Freeman. Do I have a second?
Is that okay with, I mean, do you think that gives you the guidance you're looking for?
Yes, Mr. Freeman, it does.
Thomas, I'll second.
Let's take a roll call on this one.
Thomas,
Aye.
Dixon, Freeman,
Aye.
Epler,
Aye.
Holzbauer,
Aye.
Larson.
Aye.
Thank you very much, Mr. Chairman, members of the board, for that specific direction. I appreciate it.
Thank you. Mr. Freeman. All right, the next item on the agenda is to consider the petition submitted by Sixth Mile Creek Golf Course. Water rights numbers 6073-3 and 6441-3. Ms. Newell?
Aye. So back in March, we reviewed all of the 2025 irrigation questionnaires that were not returned. We had made every effort to get them to the permit holders. We had made sure that our mail was sent out certified. We had signatures for receipts of that certified mail delivery. As it would turn out, the previous superintendent for 6 Mile Creek is no longer the superintendent for 6 Mile Creek Golf Course, and the mail was subsequently not getting turned over to the current staff of 6 Mile Creek Golf Course. As soon as they learned of the suspension of the 2 listed water rights, I was contacted by a member of the board for the golf course. They submit their irrigation questionnaire information that same day. They updated the contact information for their new staff that same day, and then they submit this petition requesting that their irrigation water rights not be suspended. So it was not that they did not wish to submit their information. It wasn't that they were intending to violate that qualification. Simply mail was not getting turned over to them. And we ran into this, I know, one time last year where the board did lift that suspension for another golf course where the mail was not being received by the appropriate parties.
Questions, comments from the board?
And your recommendation is?
To let them irrigate their golf course.
Where's 6 Mile Golf Course?
White,
Blank.
a little bit north of Brookings.
I don't golf.
That's the address.
Do I hear a motion from the board to follow the department's recommendations?
So moved.
Second.
Hepler, second.
All in favor, say aye.
Aye.
All opposed, say. All opposed, say nay. Hearing none, the department's recommendation is approved. The next item is to consider withdrawal of held applications 8088-3 and 8089-3 Collins Hutterite Brethren. Stool.
So before we conducted the 5-year review of water availability, before we brought you the results of the conducted review of water availability in the Tulare Western Spink Hitchcock and the Tulare East James, statute required that we contacted all of those applicants and confirmed that they did want their applications to be considered. We received confirmation in the affirmative from all of the applicants. After those reviews were complete and the board determined that there was not available water for appropriation in the East James Management Unit, all of the applicants were contacted letting them know of the board's decision and that per statute 46-2A 7.5, 10% of the original application fee needed to be submit to retain their eligibility for the next 5-year review. Out of all the East James applicants, Collins Colony was the only one that did not remit their fees. Notice was sent to the colony letting them know that those fees were due, and failure to submit those constitutes withdrawal of their held application per that cited statute. We noticed them of this hearing, informing them that the board would have the options to withdraw their application, defer action, or take no action.
Any comments, questions from the board? Yes, Mr. Collins.
I know you did notice legal notices, so is it out of the ordinary to call them and say, are they fully aware that?
I did actually speak to Mr. Whip from the colony, and he was informed of today's hearing.
Okay, thank you. So that you informed them of this specific hearing?
Correct. They knew that this was happening and that if they wished to oppose the withdrawal of their application, they would need to either be here or call in and voice that.
And this particular applicant was part of the Tulare?
Correct. So when we sent out the information for the original review, which we did at a previous meeting, they said they did want to maintain their status for that consideration. When it came down that there wasn't water available and that it would continue to be held for an additional 5 years, they were the only ones that didn't submit the fee to continue that hold.
They've informed that my presumption is then they went to the bottom of this list, because we got 25 new applicants.
So you are referring to the Western Bank Hitchcock. This is the East James, which there wasn't appropriated water from. So all of those East James applications are continuing to be held.
So what's your recommendation?
Statute says if you don't submit the 10%, it constitutes withdrawal of the application. I'm tasked with following the law.
Have you talked to them on the phone? Did they show any interest?
They did. They were hoping to not lose it, and I advised them that they would need to either make an appearance in person, or I gave them all the information to call in, and I advised them to be prepared to cut a check. But no one is here, no one has joined us, and they did not participate in the meeting yesterday either.
And they didn't send a check. Okay.
Your motion?
I move that, the application be canceled and withdrawn.
Have a second.
Second.
All in favor, say aye.
Aye.
All opposed, say nay. Hearing none, the motion is adopted. Thank you, Ms. Wolf.
Thank you.
The next item on the agenda is to consider application number 9019-3. Mr. Mathewitz.
Good morning, Mr. Chairman, members of the board. Adam Mathewitz, Acting Chief Engineer of the Water Rights Program. Application 9019-3 for Jimmer Dan Tyan is an irrigation application out with appropriate water from the Antelope Valley Aquifer. This one, and then one that has been recommended for deferral, in part because there is a future use application that has been contested and will be heard by this board in July that has senior priority to this. The outcome of that hearing would affect my recommendation on this application. Furthermore, there is another subsequent application in a different name, but by the same operator, Mr. Jim Tyan, that was also deferred for the Antelope Valley Aquifer because of that future use application that is to be heard by the board. I personally spoke with Mr. Tyan and alerted to him what possible recommendations would come out depending on the hearing. I discussed both potentials with him. He seemed very reasonable. I explained the other application as well. That is, it came late enough that it was just scheduled for the July meeting, where this one had to be, just with how our process works, had to come here at this date. And then the preceding future use application was auto-delayed from this meeting to the July meeting. That is why I'm recommending deferral on this application. We did do a complete review. If you'd like some discussion of that, I can provide that discussion.
Questions from the board? Do you hear a motion?
I move deferral of, application 9019-3.
Have a second?
Is that time certain? Is that time certain?
Yes.
You say July?
Yeah.
I didn't. I put a second.
All in favor, say aye. 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 All opposed, say nay. Hearing none, the motion is adopted. We'll be deferring the application 9019-3 to the July meeting, sir. July of 2026.
Yes.
Thank you, Mr. Matt.
that was the last item on the agenda. Do I have a motion to adjourn?
Before we just adjourn, I just wanna, on the record, thank the staff. This has been a long day and a half. You guys, done yeoman's work. Thank you all, being very well prepared, very professional, so. Mark, Ron, you guys do a great job, everybody, so thank you.
On behalf of Water Rights Program staff, thank you.
I would move.
Second.
There's the picture. That's.
Oh my God.
Ron is the upper left. This was the picture I was referencing yesterday. As you can see, a full head of brown hair, a big thick mustache. The other engineer, the one sitting, is Tim Shaw. He was our dam safety engineer for a number of years, those of you who remember him. This was September 1983, Ron, correct?
Yeah.
4 months on the job.
A few months after I started.
That's what Water Rights does to you. Just look at Ron. I mean, those of you who remember my first years will note there's a lot more gray in my beard and a lot less hair on top than there was, and I'm not that far.
Mr. Mathis, you had an application to make to the board, right?
Are we on the
I'm
record?
off the record, right?
I'm not on the record.
No, we're off the record. We're adjourned.
Sorry.
Okay.
The meeting is adjourned, right?
Do we need a motion, second voice vote?
Okay, well,
We did.
Oh, we did, then we're.
no, it is.
Okay.
Hold on.
We did, right?
No.
We have a motion.
So I have a motion to adjourn and then Kelly talked.
Oh.
There's no,
We have a motion. I need a second.
no, there is no motion.
I need somebody to make a motion to adjourn. Do I have a second? All in favor, say aye. Aye. All opposed, say nay. Meeting is adjourned. Now we go.
Mr. Chairman, members of the board, I have an unofficial application I would
You are listening to South Dakota Public Broadcasting's live webcast service on the South Dakota Network. More information at sd.net. You are listening to South Dakota Public Broadcasting's live webcast service on the South Dakota Network. More information at sd.net.